Good afternoon, everyone, and welcome back to this week's episode of the Digital Law Podcast, brought to you by Digital Law and produced by Anson Evaluate. As a bit of background, we're a law firm that works solely on technology, cybersecurity, and legal issues. In each episode, we look at stories in the law related to digital technology from around the world, with an emphasis on data protection and cybersecurity. I'm Amelia Davies, an apprentice solicitor at Digital Law UK, and I'm joined by my colleague Peter Wright, and we're going to run through some news stories that have been coming up this week. I'll pass over to Peter to introduce himself, and then we will get started.
Hi, my name's Peter. I'm a solicitor and the Managing Director at Digital Law. I'm looking forward to discussing some of this week's stories with you. And funnily enough, one of them is the gift that never seems to keep on giving, stop giving, which is, it used to be called Twitter and now it's called something else. So I'll pass over to Amelia to introduce that one.
Thanks, Peter. So yes, on Monday, the 24th of July, a stylized white X on a black background became the new logo on Twitter's website, although the blue bird was still seen on the mobile app. So it appears that Mr. Musk has now decided to rebrand Twitter. And this is essentially people saying that this is a simple way for Musk to make his mark on the company. And it's quite interesting. So I was having a conversation with you, Peter, earlier, saying that it seems a bit strange to essentially completely rebrand when we all know Twitter as having a little blue bird sort of logo. But you had a very interesting take on this.
Yeah, so I suppose just in terms of where they are, so this has all happened very, very rapidly from Musk saying, I was going to say that they're still saying that a post on the platform is a tweet, even though they've changed the logo. So apparently it's still a tweet, but apparently he tweeted saying, I'm looking at changing the logo and inviting contributions from people. And then sure enough, I think someone actually put up the logo, a sort of Art Deco style X, which was then the next night, I think someone projected it onto the side of the Twitter offices in San Francisco. And that's now when you log into Twitter, certainly on the desktop, what now comes up is an X while you're waiting for your feed to come up rather than the traditional blue bird. That's different on the app because, of course, the app is more dependent on the version of the app you last downloaded. So on your phone or tablet, the experience is still largely the same until your app ends up being updated, which would happen in due course. The problem, as a lot of people are seeing it, is that the way that Twitter's evolved over the last 15 years is that everyone's email signature or at the end of a blog post or whatever, it usually says, share here, and it'll say Facebook, Instagram, and there's usually the blue bird for tweet. And of course, that's not going to change. And it's not going to be the case that you can simply flick a switch at Twitter HQ and that will change. It will still mean that it'll be dependent on sites to update things, if they even bother, or will they just drop the Twitter handle from, say, an email signature or from a please share at the end of an article. So a lot of people say, this hasn't been thought through, and it's trashing the last 15 years and what they'd already established, and this is just further evidence of the death spiral for Twitter, given that already Elon Musk said a few weeks back, our advertising revenue is still half of what it was before the takeover, when a load of brands then pulled out saying, we're worried about various things, hate speech, X, Y, Z. The point being that he continues to say, well, give me an example of it, and you can't. As he did quite forcefully to a BBC journalist a few months back who said, there's hate speech on your platform. He said, show me. And he said, I've not got examples. He said, well, there you go. You were lying. You just alleged this. You didn't have examples to back it up. But I'm sure there are plenty of people out there who could point to issues and incidents they have had, because the simple fact is there are not the volume of people there moderating that there were before. But that being said, I was like, the traditional comment on this is, this is just symptomatic of it's poorly thought through. They haven't looked at the strategic, what this means. The possibility, and this is merely supposition, but let's just look at a few of the things that Musk has said in the past. One of them is that he wants to change Twitter to be the everything app, like some of the apps in China, where you can do everything from paying for your food in a restaurant to ordering an Uber to carrying out various functions of daily life, you'd use it through this app. The banking aspect to it will appeal to him because where Elon Musk made his first millions was in a banking platform that he then sold and became ultimately PayPal in the 1990s, way before all the various things he does now. And I think he actually, even before PayPal, the first startup he did, I think, was something totally different. That he sold that for a few million, then went into PayPal. You get the idea, it goes from there. But the idea of actually then, he actually does know something about this market if he wanted to make the app, formerly known as Twitter, do something in those lines. So I think the point I'm trying to make is, I don't think he's necessarily bothered about the fact that, oh, you've got all of these links where you would otherwise tweet an article. He doesn't see the future of the platform being what it's done over the last 15 years. He sees it doing everything from comms to posting to financial transactions to organising your life online, basically. And I think the Twitter Blue account is the start of that. It'll be able, Twitter Blue users can do this, they can do that. The idea is that people subscribe to that for the cost of about the same as you'd pay for a coffee per week, so a couple of dollars a week. And then you'll have access to all of these different services. So it's actually getting people onto the idea of a subscription for this, whereas, of course, Twitter, Meta's product, etc., has always been free at the point of use so far. So that's a different model as well. But I think that's why he's not really, and why his investors at the moment aren't particularly sounding the alarm over the fact that they've got this collapse in advertising revenue, because they don't see the future as being advertising revenue. The future will be subscriptions for that service. What's the legal tech argument on this? A, it's because we could see this app becoming a major player in other fields where currently there are other apps and other systems in place. It will be interesting how they do this from a regulatory perspective when you've got to look at the Digital Services Act, Digital Markets Act in Europe, where they are likely to be designated a gatekeeper and where there could be issues about how the app then opens out its use of and coming into new areas, be it banking, finance, and wider collection and storage of people's data. There's also then an interesting argument on IP in terms of who owns the rights to X.
I mean, it's literally a letter from the alphabet. How can you then go about that? And I think you mentioned potentially some arguments as the fact that Musk is already using X in a variety of his projects, including naming his own children, which controversial.
Is that X or a series of letters?
Well, yeah, exactly. But then equally, I think we need to consider how down the line, if we are thinking about Musk expanding, how that's going to have an impact on the data that they're collecting, because we only talked in our special podcast on Threads how that was collecting a vast amount of data.
Yeah.
And if we have then suddenly got an app that is in the process of doing banking, and we've got other aspects, banking being a very financially regulated service, you've got to think, okay, well then, how is this going to work? When we're talking about data protection, server locations, it's going to be very interesting to see how this sort of progresses there.
And there's also the issue of sort of the onward transfer of personal data, particularly if you say announces deals with Uber or WorldPay or PayPal or another financial. Rather than doing this from scratch, it would make sense to work with a third party to do that. But the fact remains that it's going to be difficult for him to do this whole thing potentially from scratch. But that could be what they're looking to do with a fraction of the workforce they had before. Point being that and the other thing here as well is that, as you say, it is just a letter. Now, I knew someone 15 years ago who went to court in the UK saying he wanted to copyright the use of the colour orange.
Right.
Not surprisingly, the judge said you're having a laugh and threw that one out. But it could almost be the fact that he would rely on people trying to enforce and say, you can't use X, and the court saying, well, it's a letter.
Yeah.
So it's almost like he's saying, you can't enforce that against me and I can't enforce it against you. It doesn't stop me putting that on
There is the other outlook, is the fact that
platform.
it's such a household X, you use it in everyday life.
Exactly.
If you've then, obviously Twitter changing from the last 15 years, having that level of brand recognition and then going to something as simple and easy as X, then you have got that on the flip side.
Because to a certain extent, there's an awful lot of people who do not like, use, or have any knowledge of, or go anywhere near Twitter.
Me being one of them.
Because I mean, its user base is tiny compared to Meta's products, compared to TikTok,
Oh yeah.
compared to Snap, and I think it's something like 500 or 600 million. I mean, he has said it's got record. He keeps saying it's got record volumes of user use and interaction compared to before, but it's still tiny compared to these other platforms. Albeit more, it still remains bigger than Threads at the moment, though Threads is growing. But as we've talked before, Threads will face its own legal and regulatory challenges due to its vast collection of personal data.
Yeah, exactly. I think it'll be very interesting because, like you mentioned, Peter, this is us kind of making a few educated guesses in
Yes.
terms of where
Oh, this is
X is
entirely
going.
wild speculation. Nothing more should be read into it.
Certainly, but I think it'll be very interesting to see in the coming weeks where this actually does go. And, we have seen that literally overnight this X has come about. So it'll be fairly interesting. And no doubt, as Peter mentioned at the beginning, this is the gift that keeps on giving. And I'm sure it will continue giving,
Yes.
probably for the rest of this year and many more to come.
Indeed.
So moving on to our next story, where we are again looking at a big tech giant. So hundreds of British app designers are suing Apple for $1 billion in a class action lawsuit claiming its App Store fees amount to abusive pricing. So essentially, this is looking at 1,500 app developers in the UK coming together and essentially saying that it's an unfair App Store fee. So the app makers have claimed that the commission of 15 to 30% that the company can charge them for using in-app payment systems can amount to abusive pricing. This is fairly interesting here.
It is, and Apple's had this problem before where it's been accused of abusing dominant market position in order to provide developers access to its hundreds of millions of users of its devices around the world. And we've had the Epic Games producers of Fortnite have had run-ins with Apple over their terms in terms of as a gaming as games to be able to get on there as well. So this isn't new. What's interesting is they've chosen to do this, and this is in the High Court, isn't it? I think you say that it's in the UK.
Yes, it is in the UK, yeah.
Because in Europe, you've got the introduction of the Digital Services Act and Digital Markets Act, which define gatekeepers, of which Apple is likely to be one, and then define the idea is as a gatekeeper, you are a gatekeeper to a market, and it's how you behave in your position in governing that market, and whether you're abusing that position, that actually it gives quite wide powers to the European Commission as a regulator to turn around and take action.
So what you're saying is that the fact that this could have a huge knock-on effect more long term if you're seeing that this in the UK has had such a massive effect.
Well, I think it will be. I think it'll be interesting to see if this has a knock-on effect. Certainly in Europe, we're still, the EU still has to produce its list of companies it says it's defining as gatekeepers. You know what the criteria is, but they haven't formally said these businesses are gatekeepers. And I don't think we've had that final decision yet. Though, given the size of Apple, I think it would be impossible for them not to be classed. I mean, I've had some analysts I do sometimes investment calls with analysts, and they say, "Oh, what do you think about this, that, and the other? And do you think such and such a company could be classed as a gatekeeper?" And of course, sometimes it depends. Well, how present is that brand or that product in the EU? But of course, as I say, with Apple, they're so massive and dominant that I think it's arguable that they will be classed as a gatekeeper. They will then be subject to these clear, direct rules. There isn't, I mean, you've now got in the UK, you've got the Competition and Markets Authority is setting up a sort of digital market desk that will be specifically looking at the operation of tech firms and digital services. but that's unlikely to have any direct effect on this ongoing litigation, which more than likely Apple would look to sort of pay off, deal with, settle in some way, shape or form. So, or certainly it would have done if it was a comparatively small cohort. The size of the cohort here, though, means that they may decide, you know what, we'll push this to trial just to see what happens. And in fairness, you've got good technology and construction court judges who would be. I'd be intrigued to see their position on this.
Okay.
It's one of the things. This is one of the reasons why the UK has remained over the decades a good centre for the resolution of these disputes, because you tend to think you've got good judges who understand the issues, then giving good, well-reasoned judgments on the matters at hand, and then very often the parties, in this instance, for example, Apple would hold up its hand and go, okay, well, we've lost on this issue in London. We'll therefore take those principles and apply them globally, because it would then be mainly in the interest of the rule of law. The principle that you found under English and Welsh law would probably stand certainly in any other common law jurisdiction, and then probably would serve you well, even if you're looking at a more when you're trying to comply with statutory regulation of the type that you're then getting in Europe as well. So it'll be interesting to see the approach. Do they decide to just, as usual, throw money and resources at a problem to make this class action go away? You could get some negative publicity. It will roll on for a few years. It would be a cost sinkhole in terms of paying solicitors and barristers, as well as potentially, if you lose, you're going to pay the costs of 1,500 claimants and their solicitors and barristers. So, yeah, it'll be an interesting equation for them. Do you just try and pay them off fairly early? Do you then engage in the litigious process and deal with the costs that may rack up, knowing that if you lose, you could be on the hook for a large amount in terms of the other side's costs? If you win, you'll still have to pay tens of millions to your legal advisors in London. So the lawyers will be rubbing their hands with glee at this.
But in terms of Apple, it's sort of a lose-lose situation.
Yes. Yeah.
Moving then on to our next story, we are looking at CNIL. So CNIL is the French Data Protection Authority, and they have announced that it will be opening a sandbox dedicated to artificial intelligence. So in particular here, CNIL highlighted that the sandbox is aimed at organisations facing new issues related to personal data regulation, but it does not allow for legal constraints to be lifted as in a usual sandbox. So alternatively, CNIL noted that participant organisations will benefit from extensive support of their projects. So when we were talking about this earlier, I flagged the fact that this does sound somewhat politically motivated, because as we have seen in recent headlines, we have seen how the UK is pushing for AI and how that they are hoping to support businesses and companies that are looking at investing in the AI industry. And then we have also seen how the US has then got an agreement with the UK in terms of AI and technology. So I feel like France is feeling a little bit left out here, which is why potentially they are pushing for this AI creativity.
Yes. No, yeah, absolutely right. So you actually just answered the question there in one go, Amelia. I think you're right. I think that when you look at you've got basically the AI Act coming in at an EU level, which is seen as being probably the first big piece of central legislation anywhere in the world that introduces a system of regulation around the use of AI, which will, when we look at the massive advances already being made in AI and generative AI, that has significant implications. Meanwhile, you've got the UK, which is outside of the EU's regulatory orbit, saying we are going to introduce something which is a lot more hands-off. They aren't going to introduce a regulator. They're just going to have more powers to some of the existing regulators like Ofcom, the communications regulator, and the ICO, the data protection regulator. And already tech firms like Google have turned around and said, we see the UK's proposed regulation of AI as speech marks best in class. That's Google saying that.
Yeah.
And then, we had Rishi Sunak and Joe Biden shaking hands on a raft of different agreements a couple of weeks back when they met. I mean, it was made clear there's going to be no UK-US trade deal in any time soon, and probably in the course of the next decade. But it's almost like the vestigial tail of that stillborn trade deal that Donald Trump was quite keen on, but Joe Biden isn't, is the fact that a few things have been discussed. So it's almost like, well, they've done sort of these side deals on issues like AI and tech and data. So that can be established, but it's still way short of a full-on trade deal. But we've still got these things in place. So
And I mean, you've mentioned Google there as well. And
yeah,
as we all know, Google is very much based in the US. And if they're happy with the regulatory framework in the UK, I mean, given that these big tech companies do have such an influence in the US, they're going to really be pushing in terms of, you've said the deal with Joe Biden
yeah,
and Rishi Sunak, they're going to be pushing for stuff like that to be able to have the level of technology in the UK. And then we spoke about on our previous podcast the fact that the Bard, which is Google's kind of AI take, has been released. So
yes.
when we have got that sort of infrastructure in place, it does kind of give way for that.
Google has some massive offices located in Victoria and London.
There
So they're a big employer that we're looking for, the UK is looking for them to maintain that presence as well. So I think you're quite right. When you're looking at all that, therefore some of the regulators in Europe wanting to then show, look, we're not using a big stick, we're not against innovation, we're not against artificial intelligence. Please come here. We have a friendly regime. We have this regulatory sandbox. You can test out your models and theories in a secure, safe environment, free of regulatory interference. In other words, come and work with us. Is a desperate attempt to basically say, look, there are other places you can come and do business in Europe within the European Union, and you can see France trying to put itself in pole position there, particularly as Canil's, I suppose, a little bit of a leader insofar as you've not got a single German authority when it comes to data and technology. That's done at a state level. So, for example, you've got regulators in Bavaria and Westphalia and Schleswig-Holstein has its own regulator. There's no German regulator as a whole at a federal level. That's probably going to be the same when it comes to AI. Certainly it remains the way of data. CNIL is the French data protection regulator, probably therefore looking after the single largest economy and market in the European Union. So when it turns around and says this, it's trying to take a lead and trying to show, look, this is how this can work across Europe, and please come and invest in France. Is clearly the signal they're trying to give.
And I mean, this has literally opened in the last few days, to be interesting to see who does get involved and then how this then progresses in the next few weeks and months.
Yes.
Moving then on, we seem to be dealing with kind of like all the big tech firms. So we are next having a look at Meta. So the Meta-owned social media platform will face a temporary 3-month ban on behavioural advertising based on extensive user profiling in Norway, starting from the 4th of August. This is following a ruling of the EU Court of Justice that found the practices lacked a legal basis. So although Facebook and Instagram will continue their operations in the country, behavioural advertising infringing the EU regulations on data protection is banned. Then the penalty for this is 1 million Norwegian krona, which is around 89,000 euros daily, which, that's quite steep.
It's certainly an incentive to get on with it, isn't it?
Yes.
So, okay, well, there's a few things to unpack there. First of all, Europe is not in the European Union. It is in the European Economic Area. That makes it a rule taker. It takes rules from the European Union, such as GDPR, and it has to abide by decisions of the European Court of Justice, but it doesn't have a seat at the table. It's not a member of the EU. It doesn't get to say what these rules are. Therefore, the fact that their regulator is actually turning around saying, well, we are going to take this, but we're going to then apply it and enforce it in this way is interesting and thought-provoking. And it's actually not as though, Norway is an interesting economy from the point of view that it does have a comparatively high GDP per capita. Oslo and its cities are growing very, very rapidly. It has a massive sovereign wealth fund from the money from the North Sea. And it is increasingly a little bit of a tech hub as well. So you only have to go to Oslo and there's massive new offices going up there from all of, a lot of the big companies like PwC, EY, etc., going in there to then offer consulting services to the emerging tech hub as well. So therefore, when they're turning around and taking a bit of a hammer to Meta, it's interesting that they're doing that. And again, it's on the thorny issue of behavioural advertising. Where does Meta make most of its money? Behavioural advertising. Where has it been getting a kicking from various EU regulators? Behavioural advertising. So Norway's basically saying we're doing that as well. Just because we're in the EEA doesn't mean that Meta is going to be immune from this. The enforcement mechanism, bearing in mind that enforcement usually is something that's done slightly differently by each EU regulator, the idea of the daily fine here, I think, is quite clever, because it's basically saying that this will continue to apply while you continue to engage in this course of action, and then if you change, it'll stop. So rather than just clobbering them and saying, oh, well, you were doing this certain practice, and even though you may have now stopped, we're still going to clobber you for the fact that you were doing this from this date till this date, and even though you've now changed, you've still got to pay it. To actually sort of say, well, this is actually an ongoing issue, and you are therefore subject to this daily rate until things are corrected, is a good way of being able to then focus on sort of ongoing compliance and trying to get that level of compliance from a big tech firm, using that as quite a novel stick rather than more conventional regulatory enforcement.
I think it's quite poignant as well, given the fact that we were recently obviously talking about Threads and the fact that, they are a brand of Meta, and as a result, they are collecting troves of data. And what is that data used for? Behavioural advertising. So it is very interesting that we have got now this infrastructure in place in Norway, and will we see this sort of thing spread? That's something to consider. Will other countries think, okay, well, why don't we start finding them on a daily basis rather than clobbering them after the fact?
Indeed, and this is the reason why, as we said earlier, that Threads is not operating in the European Union.
Thanks, Peter. So
probably won't be in the near future. I think we can use that as well.
Yeah, and our next story kind of very nicely segues into that, because once again, we are still sticking with Meta, but rather going down the line of WhatsApp. So WhatsApp has updated its privacy policy as of the 17th of July, and it has changed its legal base to legitimate interest. This follows an Irish Data Protection Commissioner's sanction in January. So essentially here, the EU privacy framework requires organisations process personal data under a legal basis. So previously, the legal basis which they had been using was not sufficiently founded, and they essentially said that you really need to find a new one. So they have chosen legitimate interest. And this is quite a relevant story in terms of our clients. So we are pretty much always advising clients, look, you need to find a strong legal basis for processing the data that you do, and not just throw anything at the wall and hope something sticks. You need to be specific. And let's just say WhatsApp have been very cagey and broad and not very specific. And realistically here, while it is not something that we recommend to our clients, that actually they should really consider using the basis of consent when it comes to looking at behavioural advertising and the data that they collect. So Peter, I'll pass it over to you to continue this in a bit more detail there.
Yeah, so this comes down to the wonderful world of Article 6 of GDPR. You basically have to say what is your legal basis for processing data. WhatsApp has been trying to use contract, i.e. when you open your WhatsApp account, you have these labyrinthine terms of service that are about 35 pages long that no user probably prints out and looks at, even less actually reads and understands, because it's full of legalese and technical jargon and beyond the understanding of the majority of people, including tech experts and lawyers, if we're brutally honest. So to then turn around and say, oh, well, we're relying on these contracts that people click on and don't understand, has been shown here by a decision of the court. Sorry, is it the court or the regulator, actually?
So this is the court, actually, the European Data Protection Board, and yeah.
So exactly. So it's basically saying that it is not good enough to turn around and say, oh yes, we're relying on one of these contracts that people do not read or understand.
I think it's important to flag as well that the last year, the Italian authority warned against using legitimate interests as a legal basis for delivering personalised advertising.
Yes.
So warning last year has already been mentioned in terms of using this and relying on this as a legal basis.
Exactly. So I think, okay, so WhatsApp may switch to using legitimate interest, but it's almost like the idea of parking itself on an iceberg that's melting. So, it's almost like jumping from the frying pan into the fire, and legitimate interest probably is going to be fairly indefensible. So then it becomes, well, what other basis are you going to use? The things like public task, etc. Well, they're not a public authority. They can't rely on that. They can't say that they're forced to collect this data by statute or anything else. So they're going to probably end up potentially having to fall back on consent. And a lot of people might then say, well, so what? The problem is that consent now, under the GDPR, means you have to do that under specific informed consent, i.e. people need to understand what they're consenting to. So you can't use your 35-page technical and legalese terms of use and say, oh, well, people understand that. Well, clearly they don't.
I mean, crikey, we're trained in this stuff, and even we struggle to understand what they're going on in there.
Exactly. And even then, sometimes the practices and the things they're doing don't necessarily match up with what's in the terms of use either. So, yeah, that's a hand into nothing. You can't have bulk consent. You can't sort of say, oh, well, we're doing 35 different things with this personal data. So here are 35 activities, and it's covered by a single tick. You can't have what they call sort of pre-populated consent. They couldn't take you to a page and have like 35 tick boxes that say you're happy for your personal data to be used for sales purposes. You're happy for your personal data to be transferred to carefully selected third parties. You're happy for your data to be used and stored in servers in North America. You're happy for your data to be... You get the idea. You can't have each individual thing with a pre-populated tick box, because again, people will not read through it or properly understand it.
I know from a personal perspective, anything that's pre-populated, I'm like, right, great, move on, let's go. I'm trying to do something here.
But trying to then say in front of a court, oh yes, people entirely understand with this as a basis of operation. Good luck with that. Also, it has to be time limited. So just because you collected someone's consent in 2004 doesn't mean you can continue to spam them in 2023. Sorry about that. All those companies are continuing to do that. And you'd be surprised, and numbers still do. So, the mechanism of consent is actually very difficult to operate. We spend a lot of time actually talking our clients off the ledge of using consent. A number of times we get a client who will go, oh, we want to introduce this new service or new product, and so developers have done this and they're going to rely on consent, to which you say, no, they're not. Far better to use contract or legitimate interest, but in this instance, Meta has burned its boats. It's got decisions of courts and regulators saying, we don't like you using that because of your previous practices. So that could leave them with trying to do consent, but that's going to be an administrative nightmare. You will have to maintain individual records of consent. You will have to show what date and time that was recorded, what the user understood they were consenting to at the time. You will have to return to the user regularly to say, do you continue to consent to this activity? It will become really frustrating to the user.
I think alongside this as well, it's worth mentioning the fact that obviously consent is another form of data you will end up having to collect. So we've already got Meta collecting troves of data, and yet, if we are going to be going down the legal basis of consent, look what they'll be doing, collecting more data.
Oh, the irony.
Oh, yes.
Yes. Yeah.
So it'll be interesting to see, does Max Schrems, we're always talking about Max Schrems on this podcast, does he kick off again and say, well, this doesn't work for me, have another go, try again, and we'll see what Meta decides this time.
Terrifyingly, yes.
Moving then on to our final story, we are sticking with social media platforms. So we are looking at TikTok. Not discussed TikTok in a while, and it's pretty much gone very silent on the Western front here. So previously we had talked about how in America they had been banning the use of TikTok on a state-by-state level, and now we've got the EU commenting. So the EU Internal Market Commissioner. He has said that the platform needs to accelerate its efforts to comply with Europe's new digital rulebook that will kick in August. I mean, I feel like, wow, no kidding. Definitely need to be doing that anyway.
Well, exactly. So this is back to the world of the Digital Services Act and the definition of gatekeepers that we were talking about and their obligations when it comes to the Digital Services Act in particular talks more about content and moderation and standards and being able to demonstrate safeguards are in place to a regulator. And the point here is that he's saying, well, there's a lot that TikTok will have to do in order to demonstrate they're complying with this. Suzy Chu, the TikTok CEO, has said, yeah, we're doing that, and we've got a month to go, and we know we need to improve, and blah, blah, blah. So they're clearly thinking that they can get something together by the 25th of August that will show that they can demonstrate compliance with the EU's Digital Services Act. The reason why I thought we'd add this on to as the sort of the last bit of our discussion this week is to make it clear that the issues around TikTok have not gone away. The last time I think we talked about this a couple of months back, US Congress had their hearings and they were looking pretty likely that, certainly I think if you'd asked them to take a vote on it there and then, they'd have turned around and banned it if they could, because they don't like it, don't necessarily understand it. It comes from China, and that's enough for them to turn around and say, we're going to get rid of this, thank you very much. Don't forget that TikTok has actually been banned in countries like India, and it is facing, increasingly it is being banned from use on things like government and public sector devices in a number of countries, including the UK and in the European Union. So, adding all of that up, the point there is that overall there's going to be, I think, once you get parliaments coming back in September, October, issues around TikTok will continue to bubble around. And we're seeing this, this is a comment from the EU Commissioner in July. Admittedly, it is a slow news month. We're now into the silly season. People are on holiday, regulators are on holiday. But I think we'll continue to see more of this in the autumn. And the EU is saying here that it could have an issue with regards to TikTok's compliance with the DSA. That's before you take into account some of the issues around data collection and privacy that have already been identified with regards to TikTok's operations, as well as potentially the fact that its head offices are in China and the issues around the Chinese security law that means that potentially TikTok could have to provide information to the Chinese state if it asked for it. Though the Chinese state says it wouldn't. So, roll all of that together, I think we can see the chess pieces are sort of being put into the right places so that if regulators wish to take action, they can and they will.
I think it's definitely worth considering as well, the main demographic for TikTok is the kind of age of school children. And guess what? It's the summer holidays now. So I feel like we'll be seeing the long-term effects of the use of TikTok and how this is going to go up over the next couple of weeks as schools are now out. And so I definitely think this will be coming back to bite us in the autumn when kids are going back to school with potentially addictions to social media, when they have just been left to their own devices quite literally over summer. And TikTok is where they've chosen to spend their time.
And that's quite scary. I mean, I went to one family get together a couple of weeks back, and there were two of the kids there who were both glued to their devices the whole time. Did occasionally look up. One of them cleared off to a bedroom upstairs and was, I think, engaged in gaming. Another one did sit downstairs with the adults, but was totally engaged on the phone. Would occasionally look up, use a bit of side eye, make a smart remark, and then go back to whatever it was she was scrolling through.
Gosh, if that were anything to do with my family, they get a clip round the ear and told where to put their phone.
Still below. What worried me a little bit was that still below teenage years, and I thought, even though she was sat and her parents were there, I thought they weren't actually watching what it was she had access to.
Yes.
And there's that Dove advert doing the round at the moment where they're actually showing, the advert actually includes someone who receives a mobile device as like a 12th, they're 12 years old, they receive the mobile device, and then it shows them within a year or two having problems with eating disorders, and then by the time they're 18, they've had treatment for really serious eating disorder problems, and they're gradually recovering. Because that's just it. So you can't be entirely sure what content is being fed by the incredibly powerful algorithm that's there on TikTok and the less powerful algorithm that's there on Meta's Reels, for example, on Instagram and Facebook. So, many parents out there, what are your kids scrolling through when they've gone quiet and they're looking at their devices? It's just the slightly concerning thing.
Yeah, well, on that cheery note, that's a great way to end the podcast there.
Well, the funny thing was, at one point I did say to her as she looked up from the phone, I said, what are you going to do when they ban TikTok later this year? And the look of horror and fear that came up. To which then my wife gave me a dig in the ribs and said, don't tell her that. I was like, well, they're prepared to find something else to do. It might be going back to jigsaws and things. You never know. Go back to the tragic things I like to put up with at that age, but there you go.
So that was our last discussion for this episode. But if you'd like to hear more from us, including subscribing to our newsletter and receiving information about subscriber-only podcasts, webinars, and events, then please subscribe to our premium via our Patreon channel using the link in the show notes. A big thank you to Anson Evaluate for helping us to produce this webinar. And if you would like to produce your own podcast or webinar, or you'd be interested to hear more about Anson Evaluate services, please take a look at their website that you can find at www.ansonevaluate.com. Just a reminder, these episodes are available on our website, our YouTube channel, and podcast channels as well, such as Spotify, Apple Music, Amazon, Google, and the rest. And please feel free to leave us a review. If you do have any questions about something we've talked about today, please feel free to email us at admin@digitallawyuk.com. Thank you for listening, and we hope to see you again.